thank you for joining us this evening. Again, we've got attorney Pam Keith with us. We're going to discuss harassment in the workplace. Now, if you're on the job and you probably don't recognize it, she's going to help us out. As I mentioned, she's an attorney. So, Pam, welcome back. And please give us some of your background. How did you get into the law?
Well, thank you so much for having me. And what a pleasure it is to talk about my area of expertise, which is employment law. And you asked how I got into it. Well, I started out as a young person really wanting to be a doctor. I wanted to be a sports physician, more specifically.
Okay.
And I wanted to work with a college football team. But back then, women did not really do that. And I learned along the way that I liked the football more than I liked the medicine. So perhaps that wasn't quite right for me. But one thing I was always good at was arguing and talking and speechifying, and I was always sort of naturally comfortable with it. And eventually I figured out, oh, okay, well, maybe I should study that. So I studied that in college. I studied public speaking. And then Rodney King happened. I don't know if you recall the Rodney King situation, but obviously it happened. It was a turning point in our country, and about a year later, the police officers are being prosecuted, right? And if you remember, all of them walked except one, right? And during that whole process, I was watching TV and I was yelling at my television. I was like, no, don't ask them this, say that. And how can you drop that question? You got to pick it back up and go back. And I realized that I was prosecuting the case from my living room. And in that moment, I had like an aha experience, like, oh, wait, I could do that. In fact, I think I could do that as good as they do, or even better. And in that moment, I decided I was going to be a lawyer. And I wanted to do civil rights law. I just did. And so I made a plan to get into law school. Nobody in my family had ever been to law school. So I made a plan, and I executed my plan. And lo and behold, I got into Boston College Law School and several others. And I chose Boston College. And so I flew from California. At the time, I was living in Oakland, California. Or no, I guess I was in Davis, California by then, from undergrad and grad school. And then I flew to Boston, put myself into law school. And I was like, okay, I'm here. What I forgot to do was make a plan on how to pay for law school. And so I did what so many people did. I took out a bunch of loans and somehow I got through law school and learned how to negotiate and learned the law and did moot court, did really well, ended up on law review. I competed and proved to myself that I could actually hang with these people. And then a movie came out called A Few Good Men. I don't know if you remember that movie, but it's about Navy lawyers who were defending some Marines that got themselves into trouble. And I was so moved by this because my father was in the Navy before I was born. And so I wanted to be a JAG. I was like, I could do that. So I applied and I joined the Navy and I became a naval officer. And lo and behold, I did end up defending sailors and Marines who got themselves into trouble all over the country and certainly all over the world. I was stationed in the Middle East for 2 years and spent a lot of time on ships dealing with everything from sailors who didn't show up or missed ships movement to hazing to fraud and of course all kinds of sexual misconduct and all kinds of other things. So I cut my teeth as a lawyer doing criminal defense by the seat of my pants, just like that movie you saw. And then after a while, I got out of the Navy and I joined a big law firm here in Washington, D.C. called Morgan, Lewis & Bacchus. It's one of the biggest in the country. And I wanted to prove to myself that I could compete. I wanted to show that I could make it in big white shoe firms. But they wanted me to defend employers who were accused of discrimination and harassment. And I just, that didn't sit right with me. I did not like that. I wanted to be in the antitrust department, but I ended up in labor and employment. And because I was not a big fan of defending allegations of discrimination, I went to the labor side. I went to the union side. And traditional labor is union, collective bargaining, grievances, arbitration, strike avoidance, strike strategy. And what I liked about that was that it wasn't David and Goliath. It wasn't the little guy against the big guy, because in our situation, the unions were big and powerful and well-funded. And so it was two sort of co-equal, powerful entities with a lot of money that were going against each other. And the goal here, at least our labor and employment practice, was we only represented unionized companies. So to me, it was about labor relations, right? It was as about, because you have to maintain that union relationship going forward. You're not just going to get rid of your union. That's just not going to happen. So it was about negotiations. It was about leverage, understanding that. It was also trying to find win-win solutions and being super creative. And so I learned that. And then from there, I went to other big firms. And eventually I went in-house to a large energy company in Florida. So I worked inside of corporate, boardrooms as well, making employment and labor decisions. And after a while, I woke up and I realized, like, okay, all the things I planned to do, I done. I'm here and I'm bored.
Need a new challenge.
I'm bored. I'm like, okay, like now what? And then it realized, to whom much is given, much is required. And I learned that I wanted to advocate on a different scale. And so I decided to go into politics, and I ran for federal office in Florida. I first ran for US Senate and was the first Black woman to ever run a qualified campaign for Senate in the state of Florida. Then I didn't win. Obviously, the party had their chosen ones, and it wasn't me. And then I ran for Congress, and in a very uphill battle, sort of red district, and I did that twice. And then I kind of burnt out on politics. But boy, did you learn a lot about making law and putting yourself out there, and taking arrows and rocks thrown your way, and battling through disappointments and all of those other sort of personal characteristics you need to be able to stand in the gap for others. And that combination of a really strong, thoughtful, um, credentialed legal approach with a really passionate advocacy for people, is what formed the basis of my current practice, which is representing individuals, and very specifically people of color and women in the workplace who are being bullied, harassed, managed out, who are denigrated, overlooked for promotion, paid unfairly, and they need someone who's willing to throw punches on their behalf, someone who's aggressive, assertive, and passionate in telling their story. And that's what I think my background has prepared me to do.
Oh, what a story. Okay. We know you're eminently qualified. So, Bree, you can put it on the screen that folks who got questions, who, on the job questions, or they want to comment, what do they do? They got a question for Attorney Pam Keith. So, Pam, uh, workplace harassment. How do you identify it? How do you know when they're just kidding, or just playing around, just having fun? Is there a thin line between that,
Well,
or
yeah, you know what? I want to take people back. I
uh-huh.
want to take people back to elementary school, right? Because most of what we learn on how to interact with each other, we learn in kindergarten or elementary school, right? And we know what it feels like to be included, and we
Yeah,
know what it feels like to be excluded. We know what it feels like to be made fun of. We know what it feels like to be silenced. We know what it feels like when somebody praises and recognizes your contribution, your effort, you being there. They speak with you to you in kind tones. And we know when somebody's mocking us. We know when somebody is uh, using harsh tones, cold shoulder, exclusion, right?
yeah,
And those feelings are part of what we call emotional intelligence, right? The ability to pick up hostility is very sophisticated in people, and it's very well honed, especially in minority communities and women and outsiders. You are very keen to who is a threat to you and who is welcoming to you. And you go into a workplace where you are welcomed, you feel like you can take chances, you can speak up, you can be creative, you can take initiative. But when you are constantly hyper scrutinized, when you're constantly criticized, where everything you do is wrong and you're told why it's wrong, you begin to become more and more introverted and more fearful for your job security. And it is when you operate in that space of constant fear that you are in the throes of being bullied and harassed.
right.
And it's just a question of degree, right? if every day you were dreading going to work and you feel like your job is a battle, and if every day you have a supervisor or a manager who's riding herd on you, he's checking where you are, he's changing your schedule, he's telling you you can't take vacation, you can't get overtime, you know that is different for you than others, and you go home and you stress about it, and you tell your spouse or your significant other about how miserable this person is making you, right? And if you and you have anxiety and you're starting to question whether you should even stay there, you're being harassed and bullied. You're being harassed and bullied, right? Now, maybe it's because your performance ain't good. That's possible, but it's also possible that it's just because that person that is bullying and harassing you doesn't want you to succeed. And they think they're doing the enterprise a favor by making your life so miserable that you leave. That's what we call managing somebody out.
Right.
Oh, I don't think this person belongs, so I'm going to manage them out. The question is not if this is happening to you, is it wrong? The question is, if this is happening to you, is it illegal? And in our law system, it's only illegal if the motivation for it is your race or your sexual orientation or your age or your disability, right? It's only illegal if it's for an illegal reason. And so our laws put the burden on us to prove someone else's intentions.
So let me jump in and ask you this: does it have to be a one-off, or does it have to, be something continuous?
It can be either one. It can be a one-off, like they demoted me. They denied me a promotion, or they denied me a key training that everybody else gets. But more frequently, it isn't a one-off. More frequently, it's death by 1,000 cuts. More frequently, it's a series of insults and humiliations and unfair treatments and hyper scrutiny, discipline that they gave to you that they didn't give to others, tones of voice, isolation. We know when we're getting yelled at because we have a fight or flight response to that. If you get called into your boss's office and they tell you you did a lousy job, you're going to have a lousy day, right? It's going to stay with you. And that.
Let me interrupt you on that. How do you prove that? The boss says you did a lousy job. And he says you did a lousy job. You think you did a great job. So
Right.
how do you square that?
Well, you square that by keeping receipts, right? Observe what your fellow workers are doing, and do they get chastised for the same things you get chastised for? Are they doing things a better way? Or if they're doing things a worse way, but you're the only one who gets called on the carpet, then you got something, you potentially have a case. So it's really, I mean, that is one of the things that I am working on, in addition to advocating for individuals, is pushing the needle for our jurors, our courts, and our legislators to understand that the way the law is set up is you have to prove that somebody intended to harm you because you're Black or you're woman or whatever, when nobody talks like that anymore except for GOP legislators. Like, nobody talks like that. It doesn't matter whether they think they're targeting you because you're Black, or they think they're targeting you because you're a woman, or because you're Muslim, or because of whatever. What matters is, are you the only Muslim in your workplace being targeted? Are you the only woman left out of the conversation? Are you the only Black person, the one who doesn't get promoted? It is the consequence of discrimination that matters, not the intention. But that's not the way our law is written. So you got to get a smart lawyer who has it in their heart and mind that they're going to push that envelope. They're going to push that needle. They're going to plant the seed in the mind of the judge or in the mind of the juror that what they should be listening for is the consequence, not the intention. Now, you may get the results you want, you may not. But the stronger you are at telling someone's story about what it feels like to be discriminated against, the more people's mind starts to zoom in on that. Because the other side's going to be talking about, well, you can't prove that was my intention, and you can't prove that was my intention, and you don't see, unless there's a noose and they use the N-word, that's not racial discrimination. Well, that's not 2022. We're not in 1967 anymore.
So
Those
how do
people are
you
not
prove
old
that?
enough to put a noose in your work cubicle. But that same dude that's sitting next to you may be part of the Proud Boys,
Yeah.
right?
So you're saying
So
it's more
you gotta
subtle.
come at it a different way.
You're saying that discrimination is much more subtle these days.
It's more subtle, it's more, but it's just ubiquitous, right? But it's also more carefully couched in plausible deniability.
Uh-huh.
Right. And the Republicans are getting, I mean, sorry, I hate to be political, but Republicans do get really good groupthink about plausible deniability. If they can make some kind of straight face argument to mask their intentions, then you have to accept that at face value. At least they think so. I
Yeah.
don't. Right. So I try to become as aggressive and as deft at parsing out what they're really saying and putting them on the defensive. Part of my legal strategy in every case that I take is that I don't play defense, I play offense, right? If
Okay.
my job is to make everything that your supervisor did, your manager did, your boss did, subject to scrutiny and suspect,
Mm.
right? That they're defending what they did to you rather than you trying to defend why yourself as to why they're attacking you, right? If you turn the tables and you make them explain themselves, all of a sudden it gets less comfortable. And you're more likely to get a settlement. You're more likely to get a result that you can live with, even if it's not full vindication, if you're good at doing that.
All right. We got some folks got questions for you,
Yes,
uh,
sir.
Counselor. All right, we'll start. Can we, this is Real Talk, says, can we completely eradicate workplace inequalities? If so, do you have any recommendations?
Well, I think it can be done to a greater degree, right? Like just like we can never get to perfection, we can become more and more perfect. I think the mindset shift is really what's most important. It's not just the mindset shift in white Americans; it's the mindset shift in Black Americans and women and in minorities. I categorically reject the idea that I am included in somebody's workplace or I'm included in somebody's enterprise. If I'm there, then I'm a co owner of this enterprise. Maybe not in terms of shares, but in terms of what this enterprise looks like and should sound like and feel like, because that's why my presence makes a difference. So if I have an ownership mentality, then I'm not going to be happy just being there and executing somebody else's ideas. I'm not going to be happy with that. I'm not going to be satisfied with that. And so when we talk about workplace inequalities, what we're saying is, hey, if we're here, it has to look a little bit like us. Not entirely because it's a diverse workplace, but
Right.
if we're there, it's got to look a little bit like us. It's got to feel a little bit like us, and you got to want that.
Gotcha.
Because if you don't want that, then you're not really getting the benefit of the diversity you claim. It can't, if it's an enterprise with 50 Black people, but it sounds like a white enterprise and it looks like a white enterprise and it acts like a white enterprise, then everybody's just joking. So yes, we can get there, but it takes a shift in mindset in both those in the dominant culture and those minorities, however that is defined. Everybody in the workplace is a co-owner. When you get to that place, everybody in the workplace makes that place look a little bit like them and act a little bit like them. When you get there, that is when you get the best of your investment, especially when you are a public facing enterprise that has a customer base that's diverse.
Now, does it make a difference if that particular job that you're on and they have classes in discrimination and so they for the employees and it's mandatory and you have to sign off that you went there? If they get sued, can they say, well, we did teach this class? Does that mitigate if something happens? Because usually if there's discrimination on the workplace, they're going to sue the person who they think discriminated against it, but also sue the employee.
Right. It can make a difference with respect to remediation. It can make a difference in terms of damages, right? Um, but simply telling people not to discriminate only counts if you actually hold them accountable for discrimination. And what I find is that a lot of enterprises won't do that. They will train up the wazoo, but they will not fire discriminators, right? They will move people, right? They will try, but they won't fire anybody. I think the bigger issue is this systemic, right? Is this just a one-off, or is there an assumption that we're going to keep people around who discriminate and move people out who complain of discrimination?
Yeah.
Is that the way your enterprise works? Because there are a lot of enterprises out there who just feel like they fire the person that complained and they pay them off with the settlement, and then they just keep on discriminating.
Mm. So give us how it really works. Give us a layout. I'm on the job and I feel I'm discriminated against. Everybody's getting promoted except me. What do I do? What are the steps I do before I call you?
Well, the first thing you need to do is make sure that you're documenting everything. You're taking good notes, receipts, you have comparators, people that you can show you've done more, you've been there longer, you have more seniority, and you are a direct comparator to that person. You can say, look, this is how I know I'm being treated differently. It's not in my mind. There's evidence that I can point to. Then the second thing is, usually most enterprises have an internal EEO complaint process. You don't have to use it, and sometimes it's useless, but it's always to your benefit to have said you tried, right? Because that is a sign of good faith, that you're not just out here trying to get money, but that you are trying to resolve a problem first. And sometimes that's to your benefit and sometimes that's not, right? Like, because sometimes they're going to use that opportunity to build up a case against you. But I'm just keeping it real. Sometimes they do that. But, that would be your typical next step. And then you would file a charge with the EEOC, which is the federal body that investigates equal employment complaints. It's called the Equal Employment Opportunity Commission. And virtually every state has a state equivalent to the EEOC. And most states you can file with one entity, the other, or both, right? You can have both a state and a federal EEOC type charge, right? And you're going to say, I believe I'm discriminated against, blah, 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 blah. Right. And theoretically, they're supposed to investigate your charge and investigate your situation and tell you whether your claim has any merit. Realistically, they don't have the budget of manpower to do investigations worth a damn. So they don't. They just hang on to your claim for umpteen months, and you have to wait at least 180 days. So that's like 6 months or so before you can go to court. Once you've waited 180 days and nothing has happened, because usually nothing happens in 180 days. But once you've waited 180 days, then you can go to court. Don't go to court pro se. You can, don't do it. Always get a competent lawyer to take you to court, because it is so, you will be so frustrated. First of all, you're not going to be taken seriously. Second of all, you're going to be so frustrated, and the other side is just going to run circles around you, waste your money, waste your time, right? Make you feel small and stupid. Don't do that. And yes, am I giving the world legal advice? Well, why not? We're here, so I'm telling you, don't do that.
Yeah.
The better thing to do is, if you're being discriminated against, chances are there are other people being discriminated against who look like you or who are in your situation. If they're Black, they're female, they're disabled, they're of the same age, right? Band together. You are going to have a better time litigating against an employer if it's 2, 3, 5, 7, or 10 of you. Because when you stand together, then they can't say, oh, well, this is just a disgruntled employee, right? If there's 4 or 5 of you who are standing together saying, yeah, all 5 of us are saying that this is a problem, now you have to be taken a little bit more seriously. Not only will your employer take you more seriously, but a judge will take you more seriously, and a jury will take you more seriously. So if you sincerely believe you're being discriminated against or treated unfairly, try to find some others that are willing to band with you. That gives you an opportunity to divide litigation costs amongst you, so you mitigate the cost of your litigation. You back each other up in terms of credibility, and you support each other emotionally and mentally through what is a very challenging process. So a lot of the cases that I bring on behalf of 3 or 4 or 5, and in sometimes the cases 10, people at one time standing together, speaking of one voice.
Yeah, and I'm glad you raised that point about sticking together, because I told folks that we're going to have this conversation with you, and I said, well, please ask them, because they're on a job. They haven't had a raise since 2006, and then 2007 they said it was the economy, then it was the pandemic, but they haven't got a raise. Do they have a case? Is it a class action? How should they handle that? Should they go to HR?
Okay, so if you're talking about a public entity, you're
No,
talking about
no, public.
so
No,
it's like a
it's
police or
private, yeah,
teachers.
private, yeah.
So it's a private company,
Yeah, private company,
Okay.
yeah.
So in a private company situation, it's very difficult to say, oh, I deserve a raise or this group of people deserves a raise, unless, of course, there are other people who got raises and you didn't, right?
Okay.
It's always about comparators when you're talking about a private corporation. If a division that's mostly Black, because, like, let's be honest, the unions from way back negotiated contracts that concentrated Blacks into certain job titles or concentrated women into certain job titles. If you go to a construction site, all the women are in the clerk's office, all the men are on the higher paying union jobs. Well, how does that happen? Well, that was by orchestration. That wasn't just by accident. So if you're saying, hey, there is a concerted effort to keep a certain kind of person in a job title or classification where they get paid less and they haven't gotten a raise where everybody else did, or the company breaks in billions and everybody else got a job, that because it's not against the law to be underpaid, right? It's against the law to be underpaid because you're a woman, because you're Latina, or because you have a disability. That's against the law.
Yeah.
So if you're going to say, hey, we haven't gotten a raise in 5 years, that only matters if somebody else did.
And to prove that, you'd have to file a motion to see the books?
No, to do that, you sue, right? To do that, you go through the process, you sue, and it is in the process of litigation that you get to discovery. And in discovery, you get to ask for records that establish this disparity. But you got to have something on which you base your belief that there was a disparity, right? Like you can't just be like, oh, I'm Black, maybe there's white people who get paid more than me, right? Like you have to have something that gives you a legitimate reason to believe that you are being underpaid. But for example, there are a lot of, like I said, in a lot of union workplaces, women are relegated to lower wage jobs, and they create barriers, unnecessary barriers for women to get into the higher paid jobs like forklift operators and other kinds of jobs. You have to go through the difficult menial tasks first. Why? Well, because they want to. That's why. And our labor laws give the unions a whole lot of latitude, to structure collective bargaining agreements in ways that favor certain groups over others. So don't start from the presumption that your union is going to do you right. They might not. So having somebody who actually understands that on your side can be very beneficial.
All right. A question for you. I'm not sure if it's Facebook or Twitter. In your professional opinion, are there certain occupations that are more susceptible than others?
To discrimination?
Yeah.
No. Discrimination happens everywhere. It happens at the highest levels, at the most menial levels. It happens in small businesses, and it happens in the biggest enterprises. It happens in the military, the police. It happens in government. Like if you were watching Ketanji Brown Jackson's confirmation hearings, it happens when you're trying to be a Supreme Court justice. No, it's everywhere.
All right, let's talk about harassment. What is harassment? What's the legal definition of harassment?
I'm not even actually sure that there is one. It's like obscenity. When you see it, it's this constant targeting for scrutiny, denigration, criticism, discipline, bullying, using condescending and nasty tones of voice, physically intimidating people, making fun of them behind their back or to their face. That's all in the category of harassment. But you certainly know when you're the victim of it, because there's no question about that. So the question is it when you see it, and you can describe it based on the facts of your particular case. So if you have a boss who makes gives you an assignment at 3:30 on Friday, every Friday, to screw up their weekend, but doesn't do that to anybody else, then yeah, that's a form of harassment, especially if there's no business justification for it.
But some of it can be subjective because they say, made a comment or something, or does it has to be continuous, or
It has to
or,
be consistent enough that you could say it's a hostile work environment, right? It has to be, it's not a one-off, unless it's very offensive, right? Like you call me out my name one time, that could be enough to be harassment. You call me the C word or the N word, yeah, that could constitute harassment. But usually it's not that. Usually it's a series or pattern of insults and slights and attacks, and every day they're looking for something to mess you over about, right? You can't be left alone. Nothing you do can be okay, right? And because they're riding you like they want you out, and that's how yeah, if every single day is a battle, then you're being harassed. Right? You don't have to describe that. You know how it feels, just like what it feels when somebody's bullying you in junior high. It feels exactly the same way because it's exactly the same thing.
But what about, let's talk about words, and what, because you talk about the C word, the B word. What about the N word?
Oh,
If they
absolutely.
call you the N word, I says, well, the rappers use it, and I use it too. It's as a form of endearment. So I didn't mean anything negative, pejorative about it. So it was a term I use as a term. Can they use that as a defense?
They can try. It doesn't work, right? Because context matters. That you have an advocate that can explain that when Black people use that word amongst each other, it's a term of endearment, but partly because of our intentions, but partly because we know how that person's going to interpret it. What if you were to use that word with me, or I was to use that word with you, and we were familiar, right? Not only would I know that you weren't trying to call me out my race, right? But because of our history or our relationship, you assumed I'd be cool with it, and I assumed you assumed that I'd be cool with it, and so everybody on in this conversation is trying to be cool with it.
Right.
Some white dude called me the N word. There's no history between us such that there was some understanding that I'd be cool with it, and he knows that, and I know that. So don't go for the okey doke, right? We don't know each other like that. You don't have it like that with me. So if you use that word, it's going to offend me and you want me to be offended. So don't use plausible deniability after the fact to say, "Oh, well, I didn't know you would be offended." Well, you didn't have the background to guess. So you shouldn't have gone there, because we don't have the kind of interpersonal relationship that allows you to make that assumption.
But what if he goes the distance and it goes to court and you get a judge who agrees with it?
Mm-hmm.
A good old boy, and then and shoots down your case. What's next? You appeal?
I mean, you can appeal, but it depends on how, what their basis of shooting down your cases. Most cases don't go to trial, to be honest with you. Most cases do end up settling. Why? Because it's a risk. If you get past the motion for to dismiss, and you get past a motion for summary judgment, which requires some deft lawyering quite often, then the risk for the employer is pretty high. They tend to want to come to the table and get rid of that. But again, sometimes the win is not necessarily in the money. Sometimes the win is in getting declaratory judgment, is getting a judge to say, you got to stop doing that, right? It's pretty rare, but it can happen. And a lot of the cases that I choose to pursue on behalf of my clients are about systemic change, right? They're about system disrupting.
Yeah.
I pick cases where I think I can land a punch on the employer, not just to do so, but to get them to realize that something they're doing is wrong. And not just towards my client, but basically a fundamental part of their enterprise.
All right. I got another trick question for you. What advice for sexual harassment?
Yeah.
If a woman was touched by another male coworker and the investigation concluded there was no violation.
You can still go forward. You don't have to rely on your investigation, right? You can still file an EEOC charge. You can still pursue that in court. You can still depose that, if you pursue that in court, you can still get discovery and deposition and whatever. And some of it depends on what they say. If they say there was no violation because it didn't happen, that's one thing. If they say there's no violation because he didn't mean to offend you, or it was accidental, or it was just occasional, then it really depends on the facts of the circumstance, right? It depends on whether or not there were circumstances that would lead you to believe that this was meant as a sexual overture, right? That every case is a little bit different. But if you can convince a reasonable person that this person was actually trying to touch you in an offensive and inappropriate way, and then try to use plausible deniability after the fact, then a deaf lawyer ought to be able to lay that narrative out in front of a jury or in front of a judge, and get them to see that, yeah, like, because it's not, because if he tripped on a rug and fell and grabbed your ass just accidentally to stop himself from hitting the floor, that's one thing. But we all work in workplaces. You have to be awfully close to someone physically to get your hand on their ass or their boob. That's very unusual. I don't usually let people in my personal space like that.
Yeah. So when that happens, though, counselor, can you sue the company as well, or you just have to go after the individual?
No. In sexual harassment, all of those workplace assaults and injuries and so forth, you usually do go after the employer for failure to mitigate it or prevent it or to deal with it when it happens. There are some lines. If it goes from sexual harassment into sexual assault, interestingly enough, a lot of states don't allow for the employer to be held accountable for a sexual, like a rape, but will be held accountable for sexual harassment, because harassment is not a crime, even if it's a violation, right, of the law. It's not a crime. Sexual assault is a crime. And so they say, well, if somebody commits a crime, then surely the employer never intended for somebody to commit a crime, and it's not in the scope of their employment. Whereas their interaction with you, day-to-day conversations using the N-word or the B-word or the C-word or whatever, that can be considered still within the context of their employment. If they take a pipe out and hit you across the head, there's a presumption that that's not within the scope of their work, right? There are some states that are different. The District of Columbia, for example, does have some wiggle room there where it's plausibly within the scope of their employment if they took out the pipe while they were, tasking you with something, like there is some kind of nexus with the job. But interestingly enough, if it gets to the point of real criminality, sometimes that really pulls it out of the scope of the employer's responsibility.
Yeah, but let's go back to the grabbing again. Grabs the male.
Grabs the butt.
Grabs the butt.
Then typically in that situation, I would sue the employer for negligent hiring, negligent supervision, right? Failure to train, and to prevent these things from happening. Though that's typically the context in which I would, and also just to pay you for your pain, suffering, and loss for the injury.
The employer says, "I didn't know he was going to grab your butt. Why should I pay? That's not my
There's
fault."
a theory called respondeat superior, right?
Okay.
Which just means that the employer is responsible for the acts of their employees.
So anything that happens on the job, the employee is responsible. Is that what you're saying?
I'm saying, well, no, the employer. Anything that happens on the job that's executed by an agent of the employer, which an employee would be. There's a theory that says that, the employer is responsible. Now, I'm talking just generally. It's really important that the audience knows that every state can be different, have different nuances, have precedent. The more red your state, the more pro-management your state's going to be. And so even if the law says X, the judges can say not X, not Y, not P, not Q, and not you, right? That can absolutely happen. But don't get ahead of yourself. Don't presume that you can't succeed in court and you can't succeed in fighting your employer if you get good counsel.
Right. And Cherie's tweeting that she was harassed and she walked off her job. Wrong?
I mean, well, I will always say this. The first thing you have to do, above all other things, before vindicating your rights, before suing your employer, before finding a lawyer, the first thing you need to do is take care of yourself, your mental health, and your physical well-being, above all other things. And if for your own mental health and physical well-being, you need to walk off the job. Because nothing that happens after the fact matters if you lose yourself first, if you get harmed first, if you have a heart attack, a stroke, if you, have a mental breakdown first. Take care of your physical self first. Always. And if that means letting go of a job, that means letting go of a promotion, that means walking away, walk away first and then regroup.
Yeah.
and then figure out what your options are. But I will never tell anybody to chase the case, a payday, restitution, retribution, or anything else to the sacrifice of their own physical health. Because if you do have a stroke, doesn't matter how much money you get.
Right.
Doesn't
You know, in that particular case, is there a statute of limitations? You said to, regroup and come back. How
Sure.
much time do you have?
So you have 300 days after the incident. So if it's one incident that happened, you failed to get a promotion, or you got demoted, or whatever, you got 300 days after that. If in most states, in some states, it's less than that because there's only the federal EEOC. In most states that have both an EEOC and a state entity, you have 300 days. So check that out. Don't sleep on your rights. If you think you want to go after your employer because of a singular act, then don't sleep on your rights. Go find yourself a lawyer, go get legal counsel, go figure out what your statutes of limitations are, and move. Don't wait. However, a lot of times what you're dealing with is a hostile work environment or a continuing violation. You're dealing with, like I said, death by 1,000 cuts, constant thing, day after day after day. And then the clock really starts to tick at the last, if you're still employed, the clock is still ticking, and it will keep ticking until the harassment or the hostile work environment stops. So usually a good rule of thumb is if you're still employed, your clock is still ticking.
Okay. So what constitutes a hostile work environment? What makes that? How can you say that it is a hostile work environment? Are there some guidelines that we should know?
It's too factually variable, Carl. I can't say, oh, well, yeah, if you have 4 but not 5, if you have 5 but not 4, and if you have 2, but if it's these 2 people, but it's like, nah, it's not like that. It's 100% factually dependent. Most of the time, you're in a hostile work environment if you can't stand going to work and you feel like you're in battle every day. You probably are in a hostile work environment. At least it's hostile for you. But that alone does not help you. That alone does not get you a good case. You don't have a good case because you have a hostile work environment. You have a good case if that hostile work environment is related to your race, your gender, your age, your disability, your religion, or some other protected category.
And you can be the only one who's subjected.
Most often you are.
Yeah.
Most often you are. And the thing that I think people need to understand is folks get sophisticated about hiding their racism or their discrimination. They will use Black people to hurt other Black people. They will use women to hurt other women, because in the mind of a bigoted person, as long as a woman is involved, it can't be sexual harassment. It can't be gender discrimination. As long as a Black person is involved, it can't be race discrimination. But we know that white enterprises use Black people to hurt other Black people all the dang time. Right? And the Black person asked to do that has to make a choice between their own well-being, their own career, their own promotability, and trying to stand up for you. Well, some people will stand up for you and many, many will not. And believe me, white enterprises get pretty sophisticated at figuring out which ones are going to play the okey-doke and which ones are not. Just check out Clarence Thomas.
Yeah. And kind of like with the police officers that we had last night, do you have to have more inside person? You have, if you are fighting alone, do you have somebody to co-sign that this is a hostile work environment? Does that help? Or
super important and very, very helpful to have others on the workplace that will back up what you say. And it's important to try to figure that out before you step out on your own, because you do risk your employment. You do risk your own mental health. You do risk your own financial status and your resources in pursuing these things. So think carefully about who are your friends and allies and who will hold under the pressure. Because some people will just cave. You think they're on your side, and the next thing you know, when their management threatens their job, they're out. And that does happen. But I just want to remind people that we live in a world where steady income is such a critical component to our well-being, because it's what allows us to have a home and a car and all the other accoutrements of a good life. But it's very easy to become people who live to work instead of being people who work to live. And when your job is not just what you do 8 hours a day, but it's the dominant thing that drives your happiness or your misery all the time, your life is out of whack. And you need to kind of pull back. and reassess and perhaps think of some different choices.
Now, if this causing you physical problems, should you go to a doctor and have a doctor certify that?
Absolutely. One of the things that I do is because virtually all of my clients are traumatized by the workplace, right? All of them. I insist that they get counseling and that they go get a certification of a disability related to anxiety and stress, because that gives me the tool to go to your employer and say, you know what, my client needs a reasonable accommodation of the disability of mental anxiety and stress. And maybe that's working from home. Maybe that's having a job coach. Maybe that's a different kind of intercession, right? Like maybe that's additional training. Maybe that's whatever. There's a variety of things that can be used, but most of my clients develop a disability from the stress of work. And once they've developed a disability and they're a qualified person with a disability, then there's a whole different statute that protects them.
Okay, speaking about disability, one of the things they'll do is, okay, you can stay home, we'll still pay you, and you may be off for maybe 6 months, you're still getting paid, but you're not suing them, you're sort of in a band. So how do you handle that?
Depends on the circumstances, Carl, but you have to be a qualified person and the disability accommodation has to be reasonable, right? So sitting at home not doing anything and getting paid is typically not viewed as reasonable. But there are intercessions that can be done, especially when you start to scrutinize what's causing your work stress. I have a case that I've been working on where it's really one supervisor who's driving my client absolutely crazy. But because her crazy has been documented, you know, her anxiety, her depression, her stress, her emotional pain, her palpitations and high blood pressure is documented, then that's a physical disability. And so now I can say, how do we mitigate this disability? We can start to create distance between that employee and that supervisor. And that's something that I think creatively in trying to structure.
Yeah, I have some tweets or comments actually from one person says she was terminated by whites through the use of a so-called black person. So she put so-called black person.
It happens all the time, and it happens more and more now because of the political belief set that Black people can't discriminate against Black people based on race. No. Black people can be conduits of white people's racism. But because in the mindset of certain folks, it's not racism unless I intend it, then therefore, if it's a Black person, they can't intend to harm you. And what I'm saying is that, no, it's not racism because of what you intend. It's racism because of what I endure.
Gotcha. Another comment wants to know, and this was the person who asked about the butt grabbing, says if you were available for counsel for the situation she mentioned, which she was grabbed on the butt inappropriately.
Well, first things first, I am licensed to practice law in the District of Columbia and the state of Maryland. I am not licensed to practice law elsewhere. However, one of the things that my new law firm is doing is we're going to be setting up monthly workshops with large groups of people that will be online, virtual workshops, where we talk through certain fact patterns that may be helpful to you. I can't take cases all over the country. Wish I could. Maybe someday I can. And if you know some lawyers that are looking to join a firm, let me know. But what I can do is in these workshops, these monthly workshops, we're going to help. Like, for example, we'll have a workshop on sexual harassment and help people understand kind of the fact patterns, what steps they can take. How do you distinguish an accidental touching from an intentional touching and things like that. That kind of a workshop we will do once a month. And our first one is going to be at the beginning of May. And people from all over the country can sign up for the workshops. There is a fee, but it's not an exorbitant fee. And sometimes it's just enough for you to understand whether you have a case or not, whether you want to go find local counsel or not. So if you're interested in that, there's a email address at the bottom of my Chiron here. It's Pam Keith at centerforemploymentjustice.com. That's my email, Pam Keith, Keith, at centerforemploymentjustice.com. And you can send me an email suggest with your interest in the workshop. And that is a way that you can get some really good actionable information that's not legal advice in the sense of an attorney-client relationship, because it's open to anybody that wants to pay the fee. But it gives you a starting place. It gives you a sense of, okay, do I really have a case? And what should I be thinking about? What kinds of evidence do I need to be able to go forward? And in that circumstance, we feel that it's worth doing that. Is it a little bit unusual? Yes, it's a little bit unusual because there's always this fear of unlawful practice of the law and the bar rules in various and sundry states. And so what happens is that there's a sense that legal advice is like this rarefied air that you should be paying thousands and thousands of dollars for. I just don't agree with that. Like, I just don't think that the country benefits from legal advice and legal representation being out of the reach of average people. And that's not my ministry. So from my perspective, our firm prices in a way that makes our services accessible to working class people. And everything that we do is about changing our country and our workplaces across the country to the betterment of all people. So we're doing these workshops to arm regular people with something, with some kind of information and a compass to help them figure out where to go.
Right.
And that's why we're doing it.
Right. She just tagged it. She's in Maryland.
Okay, well then maybe we can.
Maybe you can help. But
maybe we can help.
You told me in the workshop you're going to teach, you're going to show or indicate the difference between an accidental touch and
right. I mean, because yes, what is accidental and what is intentional, right? Yeah, we can work through that. We can. So I don't. The first one, our first workshop is going to be about race issues in the workplace. The second one will probably be about sexual harassment. The third one is going to be same gender harassment, which is sometimes even harder to prove. And the goal here is to give people a general idea of what the body of law is, what kinds of fact patterns are actionable and what kinds are not, how to figure out what evidence you need to really pursue a case. I'm not talking about your individual case. I'm just educating you on what's out there so that you now have far more information than you started with about how you can vindicate your rights. Like I said, I reject the idea that legal knowledge is something that should be for rarefied air. That attitude has harmed the African-American community in so many different ways, from inheritance of land to incorporation of small businesses to trusts and estates to employment law. In every way where access to information costs a lot of money, Black people suffer. And I'm just not having it anymore.
Well, good. But I got to ask you this question. What if it's two people together and nobody else sees, whether it's a touching or a conversation or the N word or the B word? It's your word against their word. How do you handle that situation?
I mean, sometimes it is my word against your word, and then it comes down to who has the greater credibility, right? What your reputation is. Are you a person known for exaggeration and histrionics, or are you a person that's rock steady, rock solid, and wouldn't say it unless there was something behind it, right? Sadly, he say, she say happens all over the place, and not just in employment. It happens in criminal law and every other kind of law and divorce law and everything else, right? And so it's just a question of, sometimes who has the better lawyer wins the case. Sometimes who has the more dogged approach and who can stay in it longer. I can't guarantee that I win for my clients, but I absolutely can guarantee that I will swing relentlessly. That I can do. Right? Sometimes you don't get what you want. Sometimes it's a swing and a miss. But if you don't swing, you always miss.
Right. So we're striving to get a Mark Furman moment. Mark Furman in the OJ trial.
I mean, it would be great if you can goad them into doing it in front of a camera, right? Or put on, carry your cell phone around with you and use that voice memo app to record your conversations. In some states,
Is that legal?
that's perfectly lawful. Check your law to see if you're a one-party consent or two-party consent state. But a lot of cases in the District of Columbia turn on somebody having their iPhone on, recording what was being said.
Could the same be done on the phone? Not just just audio.
Yeah, you can. I mean, I have a case right now where a sergeant who harassed and bullied my clients is caught on phone admitting to doing so, and exactly why. Is that going to be relevant in the case? You better believe it.
Wow, interesting. Is there anything else that you think that we should know that we haven't touched on?
I simply encourage people to start thinking more expansively about themselves and what their role in the workplace is and who they are and what they have to contribute. I think a lot of folks want Black people in their enterprises to say that we're there to prove to themselves they're not racist without really grasping what it means to have diversity of opinion and experience and mindset in the workplace. So don't sell yourself short. And sometimes the best thing for you is walking away from a toxic work environment because maybe God something has so much better planned for you. But misery in your work is it's not something you have to endure. It's not. And sometimes it just takes being willing to take a risk, maybe finding something else, going back to school, finding another lane that works better for you. But at the end of the day, you don't get these years back. You don't get these days back. Each one is a gift from the Almighty. And if every single day is a battle just to keep your sanity, then you need to make a better choice.
And if you're working for a private company, they're not necessarily have to have diversity, do they?
They don't have to, but it's better for them if they do. They don't have to. There's no law that says you have to be diverse, but there is a law that says you cannot discriminate in hiring. So
if you're the only Black person there and you're the janitor, do you have a case? Or do you have to, or is it the people?
That's not where you get a case. If you were a janitor and you sought to be promoted to some other role and they refused, you might have a case of discrimination and promotion. If you applied to that enterprise as something and they denied it, then you may have discrimination in hiring, right? If just being the only one doesn't necessarily mean that the employer discriminated because maybe nobody else applied. Remember, it's all about comparison. It's all about comparison.
And if you're the janitor and you've been there 5 years and you're trying to make a step up and you keep getting people from the outside coming in, do you have a case?
Potentially. If you can show that they're hiring people who are less qualified than you are or less experienced than you are, or they're not giving you a chance, right? Especially if there's some of their criterion have nothing to do with the job that you're intending to do, then you might have a case. At a minimum, it's worth getting a lawyer to take a look at it.
We're racing the clock, but let me read this one. It says, please hold the mayor accountable. She could have stopped a lot of what was happening.
Well, I tell you, I'm doing everything in my power to do that. Unfortunately, our system doesn't allow us to sue the mayor directly. You sue the city, and the city is defended by the Attorney General's office. But I'm doing everything in my power to pursue these cases, to fight as hard as I can, to get the public attention on these cases, because especially with respect to these amazing, courageous Black women police officers that I represent, change has been needed for decades. And it is only because of the courage of these Black women that so many other officers are coming forward about the Blue Code of Silence, not just Black women, but Black men and white men and Latino men and Latina women. And, I'm getting calls from all kinds of people because of the courage demonstrated by Black women.
Well, I have a feeling a lot of people are going to be emboldened after watching this conversation with you tonight. Before we let you go, how can folks reach you?
That, like I said, you can always send an email at pamkeith@centerforemploymentjustice.com. You can go to the website and it hit up the contact page. It's the same, centerforemploymentjustice.com. You can follow me on my social media. My social media life is really more my political lane than my legal lane. But if you want to reach out to me that way, I'm at Pam Keith FL. The letter F as in Frank, L as in Larry, Pam Keith FL. And you can also just, if you Google us, if you go to centerforemploymentjustice.com, you can also call us. Our firm number is there. So that's the best way to reach us. And thank you so much for this opportunity to talk to this audience about how to vindicate their rights in the workplace, how to think differently about what a workplace should be, and how it should really reflect them, not just tolerate them. And also how important it is to know the law and to get somebody on your side who knows the law.
So many people told me to tell you thank you, and I want to thank you too for all the work that you do, especially with the police officers. It's just cringe when I hear sisters being attacked. Sisters who are trying to help us being attacked on the police force. I'm behind you 100% on that one. Thank you for all that you do for us, Pam.
Thank you for having me.
All right, folks, we got to run. Hope you enjoyed it. Hope you learned a lot from Pam Keith, and we'll see you next time.